Here's a sentence you can say that is completely true and almost completely useless in a courtroom. I have a constitutional right that the Constitution never bothered to write down. That is not a trick, and it is not a metaphor. There is an amendment, the 9th, that says in so many words that you retain rights beyond the ones that made the list. The people kept more than got printed. So try it. Walk into a courtroom, point at the 9th Amendment, and say, "This protects a right of mine that appears nowhere else in the document." You are reading the text correctly. And you will almost certainly lose on that ground anyway. Because for 2 centuries, the one clause that openly admits the list of rights is incomplete has been the clause judges are least willing to enforce on its own. It shows up everywhere, in briefs, in law review articles, in the concurrences and footnotes of the most famous privacy cases in American law, and it almost never decides anything by itself. It gets quoted and set aside in the same breath. So the question for this primer is exactly that paradox. The 9th Amendment says the people retain rights not listed in the Constitution. Why, then, has it almost never been the sole ground for a decision? This is Do It for the Case Law, Doctrine Deep Dive Season 0, the amendments, one at a time, one sharpest gap each. Today, the 9th. Start with the text, because this is the rare provision that is not about you directly. It is about how to read everything around it. Here's the whole thing. Quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." End quote. Notice what that sentence is doing. It does not grant a right. It does not name a right. It is an instruction about interpretation, a rule about how to read the rest of the Bill of Rights. And the rule is a warning against one specific, tempting mistake. The mistake is this. Once you write down a list of protected rights, speech, religion, arms, jury trials, a natural inference is that the list is the whole set, that whatever did not make the list was not protected, and by implication was surrendered to the government. The framers worried about exactly that inference. In fact, some of them argued against having a Bill of Rights at all, on the theory that enumerating a handful of rights would be read as quietly abandoning the rest, that a list of some rights would be turned into a ceiling on all rights. The 9th Amendment is the answer to that worry. It says, do not read the list that way. There are more. The text is telling you there are more. And that worry was not hypothetical. It is the reason the 9th Amendment exists at all. When the Constitution went out for ratification without a Bill of Rights, defenders of the document argued that adding one would be affirmatively dangerous. The argument, made most famously by Hamilton in the Federalist Papers, ran like this. The federal government only has the powers the Constitution grants it, so declaring that the government shall not abridge the freedom of the press implies that somebody thought it might have had the power to do so. Write down the exceptions and you invite the inference that there was a general power in the first place. A Bill of Rights, on this view, would hand future governments a pretext to claim more authority than was ever given. That objection had real force, and the answer to it is the 9th Amendment. When Madison brought the proposed amendments to the House, he had to solve the problem his opponents had identified. How do you write down some rights without implying you have given up the rest? The 9th is the solution, and you can see the seams. It is not a right. It is a disclaimer attached to a list, a clause whose entire job is to stop a reader from drawing the wrong conclusion from the other clauses. Which means that from the moment of its drafting, the 9th Amendment was designed to be interpretive rather than operative. The thing courts criticize it for being is the thing it was built to be. Great, it helps to see the 9th standing next to its twin. The Constitution closes the Bill of Rights with 2 housekeeping provisions that work as mirror images of each other. The 10th Amendment is about powers. The powers not delegated to the federal government are reserved to the states or to the people. The 9th Amendment is about rights. The rights not written down are still retained by the people. Together they say the same structural thing from 2 directions. The document you are holding is not the whole story. It did not hand the government every possible power, and it did not catalog for you every right you have. The 9th is the right side half of that promise. The list is not the limit. Now hold on to that word, others, because the amendment tells you those others exist, and then it does something almost mischievous. It does not tell you what they are. It names the category and leaves the contents blank. It is a promise with the specifics deliberately left out, and that blank, as we are about to see, is the whole problem. A right you cannot name is a right a court cannot easily hand you. Here is where the promise meets the machinery, and the machinery wins. Courts have overwhelmingly treated the 9th Amendment as a rule of construction, a guide to reading the other provisions, and not as a fountain of enforceable rights you can sue on directly. And the single most famous appearance of the 9th Amendment in the entire body of Supreme Court law actually proves the point, because even at its high watermark, the 9th was the supporting act, not the lead. The case is Griswold versus Connecticut, decided in 1965. Connecticut had a law on the books that made it a crime to use contraceptives even for a married couple in their own home. The court struck that law down, and in doing so it recognized a constitutional right of privacy. But watch carefully where the court actually located that right, because it is not quite where the 9th Amendment would lead you to expect. The majority opinion written by Justice Douglas did mention the 9th Amendment. It quoted the clause directly as one item in a short list of provisions. But the 9th was not the engine of the decision. The engine was something else Douglas called penumbras. Here's the majority's language, verbatim. Quote, Specific guarantees in the Bill of Rights have penumbras, formed by emanations from those guarantees that help give them life and substance." End quote. The idea is that the enumerated rights cast shadows, and in the overlap of those shadows lives a zone of privacy the government cannot invade. That is the holding the case is famous for. And notice what it is. A way of finding an unwritten right, privacy, by building it out of the written ones. The Ninth Amendment is in the room, but the actual construction is done by the other amendments, stretched. So where does the Ninth get its real moment? In a separate concurrence by Justice Goldberg. And that concurrence is the closest the Ninth Amendment has ever come to center stage, which is exactly why it is so revealing that it is a concurrence and not the opinion of the court. Goldberg wanted to take the Ninth seriously as evidence. Here's what he wrote verbatim, quote, "The language and history of the Ninth Amendment reveal that the framers of the Constitution believe that there are additional fundamental rights protected from governmental infringement which exist alongside those fundamental rights specifically mentioned in the first 8 constitutional amendments." End quote. And he pressed it hard, writing that to hold a right as basic as privacy in marriage may be infringed because that right is not guaranteed in so many words by the first 8 amendments, quote, "is to ignore the Ninth Amendment and to give it no effect whatsoever." End quote. That is about as strong a defense of the Ninth Amendment as the Supreme Court has ever printed. And now, here is the tell, of the sentence that quietly gives the whole game away. Even Goldberg, the amendment's greatest champion in its greatest moment, refused to say the Ninth actually creates rights you can enforce. In the same concurrence, verbatim, quote, "Nor do I mean to state that the Ninth Amendment constitutes an independent source of rights protected from infringement by either the states or the federal government." End quote. Not an independent source of rights. Instead, he said, "The amendment simply shows a belief of the Constitution's authors that fundamental rights exist that are not expressly enumerated." So the man making the most forceful case for the Ninth Amendment in the whole United States reports stopped right at the edge and said this is not a source of rights, it is evidence that unnamed rights exist. It lit the path. It was not the ground the case stood on, and all of it lived in a concurrence, joined by only a couple of justices, not in the law the majority announced. The Ninth Amendment's single most celebrated appearance, and it is still the understudy by the express admission of its own star witness. Now fast forward and watch the same pattern hold in a completely different corner of life. Troxel versus Granville decided in 2000. The question was whether a state could order a fit parent to allow visitation with grandparents over that parent's objection. And behind the question sat a right that appears nowhere in the constitutional text, the right of a parent to direct the upbringing of a child. That right is unenumerated. It is exactly the kind of other retained by the people the Ninth Amendment gestures at. So where did the court find it? Not in the Ninth Amendment. The court found it in the 14th Amendment's Due Process Clause. Here is the plurality, verbatim, quote, "The liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children is, perhaps, the oldest of the fundamental liberty interests recognized by this court." End quote. And here is the operative conclusion, again verbatim, quote, "It cannot now be doubted that the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children." End quote. Sit with the move. The Ninth Amendment is the one clause that flatly says unwritten rights exist. But when the court actually enforced one of the most unwritten, most fundamental rights there is, the right of a parent to raise their own child, it reached for the word liberty in the 14th Amendment, the machinery we call substantive due process, and not for the amendment that most directly announces that unenumerated rights are real. Same destination, different door. And the Ninth was not the door. There is a second lesson buried in Troxel that reinforces the first, and it is about how fragile this territory is even when the court gets to a result. Troxel did not produce a majority opinion. The lead opinion speaks for a plurality, and other justices agreed on the outcome while writing separately with different reasoning. So the case that most cleanly enforces an unenumerated right in modern family law does so without a single controlling rationale commanding a majority of the court. That is the recurring texture of unenumerated rights law. The result is often clearer than the reasoning, and the reasoning is often clearer than the source. If the justices cannot agree on which clause is doing the work when they agree on the answer, you can see why none of them wants to build a doctrine on the one clause that names nothing at all. Now, everything so far has been the Supreme Court, and that is the version of this story most people tell. But if you actually practice law, the Supreme Court is not where your Ninth Amendment claim dies. It dies much earlier in a district court or a court of appeals, and it dies in a way that is worth watching closely because the reasoning is remarkably uniform across circuits that agree on very little else. Take the Ninth Circuit in a case called Strandberg v. City of Helena, decided in 1986. The plaintiffs brought a civil rights claim resting on the penumbras of the Ninth and Tenth Amendments. The court acknowledged the argument, cited Griswold and Goldberg's concurrence by name, and then said this, verbatim, quote, "The Ninth Amendment has never been recognized as independently securing any constitutional right for purposes of pursuing a civil rights claim." End quote. Claim dismissed. Notice the structure of that sentence. It is not that the plaintiffs picked a bad right. It is that the vehicle does not exist. The Sixth Circuit reached the same place in Gibson v. Matthews, decided in 1991, holding that the Ninth Amendment does not confer substantive rights beyond those elsewhere provided. and the Second Circuit put the cleanest formulation on it in Jenkins versus Commissioner of Internal Revenue, decided in 2007, a tax case in which the petitioner argued for a right to withhold the portion of his taxes allocable to military spending. The court's answer, verbatim, quote, "The Ninth Amendment is not an independent source of individual rights, rather it provides a rule of construction that we apply in certain cases," end quote. Read those three together and you have the working law of the Ninth Amendment in the federal courts. Not a circuit split. A consensus. The 10th Circuit has said the same thing in more recent cases, citing Strandberg and Jenkins as settled, and district courts across the country repeat the proposition as though it were black letter, because functionally it is. The Ninth Amendment does not create a private right of action. A claim that rests on it alone is not weak, it is unavailable. And that consensus produces one more consequence that is easy to miss. Because the Ninth Amendment supports no cause of action, it almost never gets litigated on the merits, which means no court ever has to decide what a retained right actually is, which means the law never develops, which means the next court has even less to work with than the last one. The silence compounds. 2 centuries in, the clause is not unsettled, it is unbuilt. Is there any counterexample at all? There is one, and it is instructive precisely because of how it ended. In the litigation that eventually reached the Supreme Court as Bowers versus Hardwick, a federal court of appeals struck down a sodomy statute on privacy grounds drawn from several constitutional provisions, and the Ninth Amendment was among them. That is about as close as the clause has come to doing real work in a judgment. But it was one strand of a multi-provision privacy rationale rather than an independent holding, and the Supreme Court reversed. So even the best candidate does not establish that a Ninth Amendment holding was ever necessary to a surviving federal judgment. Weigh it honestly, it shows the argument was once made and once briefly succeeded, and it also shows what happened next. There is a reason for the hesitation, and it is worth stating fairly, because it is not simple laziness. Compare the Ninth to almost any other clause in the Bill of Rights. The First Amendment tells a court exactly what to protect: speech, press, religion, assembly. The Fourth names searches and seizures. The Sixth names the right to counsel and to a jury. Each of them hands a judge a subject and a standard. The Ninth Amendment names no rights. It says others and stops. And a clause that protects unnamed rights hands a judge something close to a blank check. With no text to cabinet, what stops a court from declaring anything at all a retained right of the people and striking down any law it dislikes in the name of a right nobody wrote down? Judges across the spectrum have flinched from that for 200 years. The fear is that a freestanding Ninth Amendment has no limiting principle, no way to tell a real retained right from a policy preference in a robe. So instead, they route the rights it points to through provisions that at least carry some anchoring language, the penumbras of the enumerated rights, or the liberty of the 14th Amendment. And they leave the Ninth as the thing you cite, not the thing you win on. So here is the thesis, and it is a narrow, precise one. The Ninth Amendment makes a promise and withholds the machinery to keep it. It promises that unenumerated rights exist, others retained by the people, and it supplies no mechanism to identify them, no standard to measure them, no cause of action that runs on the Ninth Amendment alone. It is, in a real sense, the Constitution's most cited, least enforced provision. Everyone reaches for it. Almost no case actually turns on it. It is an open, textual admission that rights exist beyond the list, paired with a 2-century judicial refusal to be the institution that says which ones. Think about how lopsided that is. The Ninth Amendment gets invoked constantly by litigants reaching for a right the enumerated clauses do not quite cover, by scholars arguing over what the framers meant, by judges dropping it in as interpretive backup for a conclusion they reached on other grounds. It is one of the most talked about sentences in the whole Bill of Rights. And set against all that invocation, the count of Supreme Court decisions that actually rest on the Ninth Amendment as their operative holding sits at essentially zero. That gap, between how often the clause is cited and how often it decides anything, is the enforcement gap. It is not that the Ninth is ignored. It is that it is used for everything except the one thing a rights provision is supposed to do, which is win a case for the person whose right was violated. And notice how neatly the anchors draw the shape of that gap. In Griswold, the Ninth Amendment gets its greatest moment, and that moment is a concurrence, in support of a right the majority grounded in the penumbras, written by a justice who expressly denied the Ninth as an independent source of rights. In Troxel, the court enforces a genuinely unenumerated right and grounds it in the 14th Amendment, not the Ninth. And in the courts of appeals, where ordinary litigants actually are, the answer is not even close. Not an independent source, no civil rights claim, rule of construction only. Put those together and you have the whole story of this amendment. When the unwritten rights it promises actually get protected, they get protected through some other clause. The Ninth Amendment points at the room where the extra rights are kept, and then hands the key to a different amendment. It gets cited to prove the list is incomplete and then set down before it has to decide anything on its own. Most cited, least enforced, an acknowledgement without an enforcer. One practical note before we close, because this is a show for people who file things. If you are drafting, do not plead the Ninth Amendment as a standalone count. On the current federal law, that count is dismissible on the pleadings in every circuit that has addressed it, and pleading it can cost you credibility on the claims that might actually work. Use it the way the courts themselves use it, as an interpretive argument against the inference that an unlisted right was surrendered, attached to a clause that does supply a cause of action. The Ninth Amendment is a very good reason why a narrow reading of another provision is wrong. It is not, right now, a place to stand on its own. That is the sample. A full Amendment 9 season on this show would live in exactly the territory this primer only touched, the interpretive battleground. What did others retained by the people mean to the people who ratified it, and what should it mean now? Is the Ninth Amendment a source of rights, or only a signpost pointing at them? How do the originalist reading and the living Constitution reading actually cash out when a real case is on the table, with a real litigant asking a court to name an unenumerated right? And how does the Ninth sit next to its neighbors, the 14th Amendment's due process, the long-buried privileges or immunities clause, each of which has at one time or another quietly done the job the Ninth Amendment was supposedly written for? One doctrinal question per episode, each anchored in cases we verify, not cases we merely remember. A quick word on how this show works. Everything you just heard is legal education, not legal advice. We are teaching how a doctrine moves, not telling you what to do if you are ever the person whose rights are on the line. And everything is built on real, named, verified cases. Griswold, Troxel, Strandberg, Gibson, and Jenkins were all pulled from the court's own opinions before I wrote a word, and every citation is in the show notes. That is the whole ethos, and it is the name of the show. Do it for the case law. I'll see you at the next amendment.